backdrop of millions of illegal migrants entering the country, as well as a crime wave happening in most major cities, well, the Supreme Court of California just handed down a new ruling saying that both police officers as well as sheriff's deputies are no longer allowed to detain people on the street just because those people were trying to evade the police. Meaning that a person trying to conceal himself from the police is no longer enough justification by itself for that person to be detained by the police. Let's go through the case together. Back in 2019, late at night, a man by the name of Marlon Flores was standing on the corner of a street in an area of Los Angeles which is known for heavy narcotics use as well as generally the heavy presence of gang activity. Then a police cruiser with two officers drove by, and Mr. Flores, he walked over and tried to hide himself behind a parked car. Here's specifically how these events unfolded according to court documents. Quote, in May of 2019, around 10 p.m., Officer Guy and his partner, Michael Marino, were on patrol in the area of Mariposa Avenue. Officer Guy considered the location to be a known narcotics area and gang hangout. He had arrested someone in the vicinity the night before for narcotics crimes. As the officers drove by a cul-de-sac, they saw Flores standing alone in the street beside a Nissan parked at a red curb. Flores looked at the officers, walked around to the back of the car, and then ducked behind it. And so the officers pulled up, they parked behind this Nissan, and then for about a minute, Mr. Flores was observed hiding behind the Nissan, popping his head in and out, until eventually the officers got out of the cruiser and approached him. He was pretending to tie his shoes, and generally seeing the suspicious behavior, as well as the neighborhood and the time of day, the police officers detained Mr. Flores and conducted what's known as a Terry stop. And in case you're not aware, here's what a Terry stop is, as well as how it generally came to be. Quote, in the landmark 1968 ruling in Terry versus Ohio, the U.S. Supreme Court determined that police can use the stop and frisk procedure under the U.S. Constitution. That established the concept of a Terry stop, which allows police to briefly detain a person based on a reasonable suspicion they are engaging in criminal activity. And so Mr. Flores was detained and had his hands placed in handcuffs. Now, eventually, it was determined that the Nissan that was illegally parked belonged to Mr. Flores, the one that he was hiding behind. He allowed the officers to retrieve his wallet from the car, upon which time the officers found a drug pipe sitting out there in the open. Inside of his wallet, they found a folded-up dollar bill containing meth, and then in a backpack within the car, the officers found a loaded, unregistered handgun, which, just for your reference, is illegal to carry in the state of California. Mr. Flores was then arrested and charged. Now, at the lower court level, the judge ruled against Mr. Flores, writing the following in the ruling, quote, Mr. Flores ducked down behind a car and later continually moved his hands, keeping them out of sight of the police as officers approached him. Mr. Flores claimed that he was tying his shoes. However, the officer would have valid suspicions if the individual picked an unlikely moment for the task in the dark, just after seeing the police and just after ducking once already, and if the person took an unusually long time at it. Mr. Flores was in a crouching position for a suspiciously long time, warranting police officers' decision to apprehend him. And as such, Mr. Flores was convicted on the gun charge after taking a plea deal and having the narcotics charge thrown away. However, he then appealed that decision to the California Court of Appeals. But in 2021, the appeals court also ruled against him, writing the following, quote, prosecutors were not able to determine whether Mr. Flores was engaging in illegal drug activity, but that the trial court was right that together the facts justified this Terry stop. In combination with other factors, a reasonable officer had a reasonable basis for investigating further to resolve this ambiguity, because nervous and evasive behavior is a pertinent factor in determining whether suspicion is reasonable. And as such, the appeals court upheld the conviction. However, Mr. Flores, he went ahead and he appealed again, this time to the state Supreme Court. And after roughly 3 years of legal back and forth, last Thursday, the state Supreme Court came back with a unanimous ruling in favor of Mr. Flores. Specifically, in a 7-0 decision, the state Supreme Court of California, they ruled
That's
that hiding yourself
ridiculous.
from the police or just trying to avoid contact with the police is not by itself enough justification to be detained. Quote, the fact that a person appears to be concealing him or herself or acting nervously cannot be the only reason for an officer to detain the person. Those actions can be relevant context, but there still needs to be reasonable suspicion of criminal activity. Law enforcement officials may consider what they see in plain view, and they can approach people in public, engage them in consensual conversation, and take note of their appearance and behavior. However, there needs to be probable cause because the individual is constitutionally protected and empowered to go on his or her own way. Meaning, the state Supreme Court ruled that a person is well within their rights to just ignore the police and go on their merry way as per the Fourth Amendment. Although the state Supreme Court did make a special point of mentioning in their majority opinion that police officers do still have ways to deal with situations like with what happened with Mr. Flores. Here's what they wrote in the relevant portion of the majority opinion. Quote, our conclusion does not leave officers without the means to follow up on behavior they view as calling for additional investigation. Flores was present in a high crime area and repeatedly tried to avoid being seen by or engaging with the police. Those facts are certainly noteworthy. The officers would have been well within the bounds of the Fourth Amendment to continue to watch Flores as he stood on the street. They were entitled to approach Flores and engage him in consensual conversation. They could have asked if he needed assistance or had himself noted anything out of the ordinary in the vicinity. If they made additional observations while doing so, those observations may have changed the calculus. But Flores' mere refusal to cooperate did not furnish the minimal level of objective justification needed for a detention or seizure. And as such, Mr. Flores cannot go back to the lower court and attempt to have his conviction overturned. Now, on the one hand, the advocacy groups who were pushing this case forward over the last several years, they were quite pleased with this ruling, saying that it will help minorities from being racially profiled. For instance, one of the attorneys for Mr. Flores, he called this ruling a, quote, vindication of the rights of minorities, adding that the outcome was possible because of the Racial Justice Act, a 2020 California law that prohibits discrimination in the state's criminal justice system based on a defendant's race, ethnicity, or national origin. On the flip side, however, you had the LA Police Protective League, which is a local police union, say that this ruling will lead to more crime in the state. Here's part of their statement. Quote, for most residents living in high crime neighborhoods, this is called good police work. Yet, in their infinite wisdom, California's out-of-touch Supreme Court overturned two lower court rulings that found the officers acted lawfully and sided with the drug and gun-possessing owner of the illegally parked car to further cement California's criminal justice system as the joke it is. Now, in terms of the next steps, it's not clear yet whether this ruling will be appealed to the U.S. Supreme Court, because just on the face of it, it appears that this California ruling directly contradicts the plain language of that earlier Supreme Court ruling, the one from 1968 in Terry versus Ohio. That was the one that established the police constitutionality of stop and frisk procedures in the first place. At the moment, there's no mention of an appeal from the relevant parties. We here at the Epoch Times, we did reach out to both the LA Police Union and the LA County Police Department for comment, but we have yet to hear back. Once we hear back, I'll let you know right away. Until then, I'll throw a link to the PDF version of the state Supreme Court ruling. You'll be able to find it down in the description box below if you want to dig into the weeds. And also, I'd love to know your thoughts. Do you think this ruling will make it more difficult for cops to do their jobs, especially when they're already dealing with gang-infested streets as well as a hostile California legal environment? Or do you believe that this ruling is a net positive? Because after all, it does secure the rights of U.S. citizens from being detained for simply trying to avoid the police. And also, what do you make of the claim that this type of a ruling helps minorities specifically? Because, at least for me, it's always a big question mark how you can say that taking criminals off the street hurts the people who are living on those streets. I mean, as a practical matter, if you remove the meth and illegal gun-carrying criminals off the streets where minorities happen to live, well, I would imagine that the law-abiding people in that neighborhood would probably actually really appreciate it a lot. You might remember how shortly after President Trump's home in Mar-a-Lago was raided by the FBI, this photo right here was released to the public, showing a variety of documents strewn out on the floor for the world to see. Looking at it, most people were shocked that these documents were clearly marked right there on the front covers as being either secret or top secret. In fact, news outlets ran that photo, publishing articles like this one here titled, quote, photos show boxes of classified documents all over Trump's Mar-a-Lago estate. However, the only problem is that, according to newly released court documents, it appears that the covers of those documents in those photos were actually put there by the feds who raided Mar-a-Lago. They were not there previously. But that's only part of the revelations that came out in these documents. Let me give you a brief bit of backstory here. Back in the fall of 2022, Judge Eileen Cannon, who is the judge overseeing the classified documents case, she ordered the prosecutors to digitally scan all the documents that they took from Trump in order to check whether or not they wound up seizing any records that were legally privileged. And so, roughly 2 years ago, Jack Smith and his team of prosecutors, they made digital scans of all the records in all the 33 boxes that they took from Mar-a-Lago. They then removed the classified documents from those boxes, put instead placeholders for where they used to be, and then they gave those boxes back to Trump's legal team so they can build a defense. And it's worth noting that during a court hearing less than a month ago, the prosecutors told Judge Eileen Cannon that everything in the boxes was exactly as they found it. Quote, when Judge Cannon asked during the hearing whether the boxes were in their original intact form as seized, one of the prosecutors responded by saying they are, with one exception, and that is that the classified documents have been removed and placeholders have been put in the documents. However, you fast forward to today, and Trump's legal team came across something strange. Trump's defense lawyers were having trouble figuring out precisely where particular documents had come from within these 33 different boxes. Things were just not making sense to them because the digital scans were not lining up with what they were actually seeing in the boxes themselves. And as such, Trump's legal team, they asked for a short delay in the case. Although, to be frank, Trump's legal team's entire strategy is to delay the case past the election, and so this might have just been a pretext to do so. But regardless, that's what happened. The boxes were not lining up with the digital scans, and so Trump's legal team requested a short delay. And interestingly, in a court filing as a response submitted last Friday, Jack Smith and his team of prosecutors admitted that despite saying what they previously said, the documents were jumbled up, meaning that the order was not the same. Here's specifically what they wrote in a court filing, again published last Friday. Quote, since the boxes were seized and stored, appropriate personnel have had access to the boxes for several reasons, including to comply with orders issued by this court in the civil proceedings noted above for investigative purposes and to facilitate the defendant's review of the boxes. There are some boxes where the order of items within that box is not the same as in the associated scans. And then, interestingly, in a footnote in their filing at the bottom, they admitted that federal prosecutors effectively misled the court by saying earlier that the evidence was exactly the same as when it was seized. Here's what they wrote in that little footnote. Quote, the government acknowledges that this is inconsistent with what the government counsel previously understood and represented to the court. Now, Jack Smith and his team of prosecutors were not able to confirm exactly why the order of papers was changed, but they did offer up a theory. Quote, the boxes contain items smaller than standard paper, such as index cards, books, and stationery, which shift easily when the boxes are carried, especially because many of the boxes are not full. And as such, they said that it wasn't really a big deal because the items in the box were the same, just the order was jumbled. Also, as a side note, in the most recent filing, the prosecutors also revealed to the court this little tidbit. Quote, Jack Smith's team revealed in the filing that FBI agents carried printed classified cover sheets during the August 8th, 2022 search of Trump's Mar-a-Lago estate and used them to replace any classified documents they discovered in cardboard banker's boxes that littered the former president's residence. They wrote in their filing that the investigative team used classified cover sheets for that purpose until the FBI ran out because there were so many classified documents, at which point the team began using blank sheets with handwritten notes indicating the classification level of the documents seized. Meaning, as a practical matter, that all those famous photos plastered on every single news channel wasn't actually how the feds found those documents. Those cover sheets with the big words secret or top secret were added by the feds themselves. And as such, President Trump used this admission of the prosecutors in their legal filing to call for the entire case to be dismissed. Here's part of what he wrote on Truth Social. Quote, deranged Jack has admitted in a filing in front of Judge Cannon to what I have been saying happened since the illegal raid on my home, that he and his team committed blatant evidence tampering by mishandling the very boxes they used as a pretext to bring this fake case. And wouldn't you know it, just yesterday, Judge Eileen Cannon went ahead and she placed the whole case on an indefinite hold. She did not dismiss the case, but it's placed on an indefinite hold. Specifically, on Tuesday, Judge Cannon postponed a filing deadline for Trump's legal team, but then the very next day, on Wednesday, she postponed the entire case indefinitely. Here's specifically what she wrote as a part of her order, again, on Wednesday. Quote, the court also determines that finalization of a trial date at this juncture, before the resolution of the myriad and interconnected pretrial and Classified Information Procedures Act issues remaining and forthcoming, would be impudent and inconsistent with the court's duty to fully and fairly consider the various pending pretrial motions before the court. The court therefore vacates the current May 20th, 2024 trial date and associated calendar call to be reset by separate order following resolution of the matters before the court, consistent with the defendant's right to due process and the public's interest in the fair and efficient administration of justice. Meaning that, as a practical matter, the case has been postponed until further notice. And of course, the underlying issue at play here is that if the case is postponed beyond the 2024 election, and if Trump happens to win that election, then the whole thing will be postponed by another 4 years, since Trump cannot be tried while serving as the sitting president. For your reference, in case you're not aware, the election is 178 days away. And so we'll just have to wait and see whether these myriad of pretrial motions that Judge Cannon mentioned can be resolved before then.
Say goodbye.